Perhaps you have heard about the franchise in Indonesia, but now we are discussing more depth about the franchise according to Indonesia regulation aspects. In the era of globalization, which is marked by several things, including the rapid advancement of information and transportation systems, causing increased relations between people around the world, especially in the economic field. The emergence of globalization is inseparable from the strong desire of developed countries that want an international trade transaction systems that is free from the protectionist system of each country. Then it extends and penetrates into almost all fields of life, ranging from culture, politics, defense systems, even law, has also experienced a process of internationalization that penetrates the boundaries of a state's territory. Therefore, international developments and trends property rights or IPR. Currently, we can see the role of IPR, which has penetrated all borders between countries, and there are efforts to provide greater protection, especially in developed countries. Indonesia, as a country that wants to advance its industry and trade inevitably must participate in the era of globalization with all preparations to adjust and anticipate aspects that will occur, both negative and positive aspects of globalization, especially in the economic field. Franchise is not a new industry, although its juridical legality was only known in Indonesia in 1994 and 1997, with the issuance of government regulation number 16 of 1997 concerning franchises and decree of the Minister of Industry and Trade of the Republic of Indonesia number 2591 of 1997 concerning provisions and procedures for the implementations of franchise of business registration. Licensing is a form of business development that involves granting permissions of or rights to utilize, use, or exercise the licensor's intellectual property rights. As with licensing, franchising also relies on the ability of business partners to develop and run their franchises business activities through procedures, processes, and a code of conduct and system determined by the franchisor. Franchising is used as a means of developing businesses without borders to all parts of the world. This means that a franchisor must know exactly the legal professions that apply in the country where the franchise will be granted or developed, so that later franchises do not turn from business partners into competitors. The development of franchising in Indonesia is now very rapid. The term franchise is the equivalent of the term franchise, which was first introduced by the Institute for Management, Education and Development, or LPPPM. The term franchise is a combination or combinations of the word wara, which means more or special, the word profit, which means profit, so that a franchise is a business that makes more or special profits. A privilege to do certain things granted by the government to individuals or companies, and the right is not owned by the populations at large. A privilege granted or sold, such as to use a name or sell a product or project service. The right is granted by a manufacturer or supplier to retailer to use its products and name under mutually agreed terms and conditions. In simple terms, a franchise is a license from the owner of a trademark or trade name allowing others to sell products or services under the name or brand. In the broad sense, that franchising has evolved into a more extensive and detailed agreement. Franchisee conducts business or sell products or services in accordance with the methods and procedures prescribed by the franchisor, and the franchisor undertakes to assist franchisees through advertising, promotion, and other consulting services. Franchising, according to Big Indonesian Dictionary or KBBI, is a corporation in the field of business with profit sharing in accordance with the agreement, management rights, marketing rights. In carry out franchise activities, it must be contained in agreement. The franchise agreement in question is reviewed from the civil code. So the franchise agreement must fulfill the principle of freedom of contract. The principle of freedom of contract will have a mutually beneficial impact between the parties who make the agreement and who agree to the agreement. From an agreement that is mutually beneficial to both parties, there will be legal protection. Franchising business practices in Indonesia have occurred before 1995, but the term franchise only appeared for the first time in Law Number 9 of 1995 concerning small business. In Article 27, letter D states franchising is one of the partnership patterns. What is meant by the franchise pattern is stated in the explanation of Article 27, letter D, which reads D is a partnership relationship in which the franchisor grants rights to the franchisee use of its license, trademarks, and distribution channels to the franchisee with the assistance of management guidance. In Indonesia, the existence of franchises is the existence of ST Indonesia, Konichiwa, CFC, Esteller 77, Indomart, Alfamart, Biru Drinking Water, Refill Depot, Ki 24 Farmasi, Warung Tegal or Warteg, Karisma Bahari, Ayam Gepuk, Bakmi Naga, and so on. Franchising in Indonesia is most recently regulated in the Minister of the Trade Regulation or Permendag number 71 of 2019 concerning the implementation of franchising. The implementation of a franchise is based on franchise agreement made between parties who have equal legal standing. Franchise is one of the effective ways to answer challenges in modern times because it does not require direct investment but involve other parties to cooperate. In the franchise system, franchises are granted to the right to utilize the intellectual property rights and operational systems of the franchisor, whether the use of trademarks, service marks, copyright on logos, industrial designs, patents, or trade secrets. The franchisor receives royalties for the use of intellectual property rights and operational system by the franchisee. This means that the franchisee runs its own business by utilizing the methods and procedures established by the franchisor, which has the further consequence that a business with the franchise system is independent business that cannot be combined with other business activities. so that the granting of a franchise must be exclusive, even requiring a non-competition clause for the franchises until the end of the franchise grant. According to Richard Barton Simatupa, franchising is a method of doing business, namely a method of marketing goods or services to the public, namely a system of marketing or distribution of goods and services, in which a parent company or franchisor grants individuals or other small and medium-sized companies or franchises the privilege of carrying out a certain business system in predetermined manner during a certain time in a certain place. When the franchise has the status of a limited liability company or PT, that is a legal entity, it must obtain approval from the Minister of Law and Human Rights in accordance with Article 7, Paragraph 4 of Law Number 40 of 27. Concerning limited liability companies, with status, the company obtains the status of legal entity on the date of the issuance of the minister decree regarding the authorization of the company's legal entity. In the implementations of franchising in Indonesia, the approval of the Minister of Trade must be obtained. Instead of obtaining approval Instead of obtaining approval from the Minister of Law and Human Rights, because the implementation of franchising is regulated in regulation of the Minister of Trade or Permendak number 71 year 2019 concerning the implementation of franchising. The implementation of guidance, evaluation, and supervision of franchising is carried out by the government, in this case, the authority of the Minister of Trade. The implementation of franchising by Minister of Trade, Regan or Mayor, is the evident from the issuance of franchise registration certificates or STPW as stipulated in Article 11, Paragraph 2 of MOT number 71 2091, which reads STPW is issued by the OSS institution for and on behalf of the minister or region or mayor. The parties to the franchise are the franchisor, franchisee, advanced franchisor, and advanced franchisee. Basically, the authority of the parent company is to act as a central leader in controlling and coordinating subsidiaries collectively as a management unit, so it is called a holding company. According to Sulistiowati, there are three characteristics that indicate the relationship between holding companies and subsidiaries, which is which are one, holding companies and subsidiaries are independent legal entities that are closely interrelated. Number two, there is a fact of the parent company's control over the subsidiary company from the business reality of the parent company. Number three, holding company as an economic unit. Based on law numbers 40 of 2007 concerning the limited liability companies is not regulated. It does not regulate the relationship between holding companies and subsidiaries, but the law used the words parent and subsidiary as contained in Article 84, paragraph 2, letter B of the law, which reads, shares of the parent company controlled by its subsidiaries directly or indirectly. Franchising as a business concept can be grouped into microeconomics as a microeconomic studies that behavior of individual within each economic unit who may act as consumers, workers, investors, owners of land or other resources, or the behavior of an industry. Franchising as a business concept, the definition of business has a narrower or special understanding of the term economy or general, namely business is more focused on commercial and interaction of the perpetrators, namely related to the economic company or microeconomics. The character of business is the goal of achieving profit, including production, distribution, and sale of goods and services for profit. Franchising as business concept can be grouped into microeconomics because microeconomic studies how to the behavior of each individual in each economy unit who can act as consumer, worker, investor, land or other resources or the behavior of an industry. Franchising as business concept regarding the granting of the use of intellectual property rights and operational activity systems by the franchisor to the franchisee is a legal relationship between the franchisor and the franchisee that is regulated in a franchise agreement, which is an agreement that documents the legal relationship regarding the obligations that exist between the franchisor and the franchisee. In terms of scope and concept, a franchise contract falls between a licensed and a distributor. The granting of permission by intellectual property rights to other parties to use certain brands or procedures is an element of a license agreement. When viewed, when viewed in terms of equity licensors product, it is part of the distributor. In a license contract, the franchisee is obliged to pay a certain amount of royalty for using the trademark and product manufacturing process, the amount of which is determined by agreement. Your royalties are sometimes not based on percentage of profits, but rather on a number of units. In an agreement, the parties involved in the franchise agreement are considered valid according to the civil code must fulfill in the elements. One, the agreements of the parties, which means that in the making of the agreement, there should be no compulsion, fraud, and oversight. If there is no agreement from the parties, the agreement can be cancelled. Number two, the parties must be capable or able to act in law, meaning that the parties making the agreement must be able to make an agreement. Capable people are adults and people who are not under guardianship, such as mentally ill people, gamblers, or something that. Number three, a certain thing that the agreement includes the object of the agreement. For example, the type of franchise in question is a type of food or beverage franchise. If the object does not exist, it will lead to null and void or invalid. And four, halal cause, meaning that the agreement made does not conflict with the law, regulation, religion, public interest, and decency. According to Salim, in principle, contracts, the aspect of their name can be classified into two types, namely nominal contracts and in nominal contracts. Nominal contracts are contracts or agreements known in the civil code, while in nominal contracts are contracts that arise, grow, and develop in practice. According to Salim, from the regulatory aspects, there are three types of in nominal contracts, namely in nominal contracts that have been specifically regulated and outlined in the form of laws or have been regulated in separate articles. In nominal contracts that have been regulated in government regulations, in nominal contracts that do not yet exist in Indonesia. Based on these criteria, the franchise agreement is included in the nominal contract that has been regulated in government regulation government number 42 of 2007. The existence of legal agreements related to franchising in Indonesia is a form of a state protection that protects business actors to advance, not only move monotonously. This journal analyzed from a legal point of view the implementation of franchise business in Indonesia and supporting factors from franchise business. The growth of franchise in Indonesia began because the existence of KFC, McDonald's, Burger King, Wendy's in 1980 to 1990. For the local franchise pioneer is S. Taylor 77. Based on the contents of Book 3 of the Civil Code, the franchise in its implementations at least fulfill the principle of balance, the principle of consanguinity, the principle of good faith, the principle of confidentiality, the principle of legal equality, and the principle of freedom of contract. The principle of freedom of contract is a universal principle because it does not only exist in the civil code. The principle does not stand alone. Its meaning can only be determined after we understand its position in an integrated relationship with other principles of treaty law, which as a whole these principles are pillars, poles, foundations of treaty law. The principle of freedom of contracts relates to the contents of the agreement. That is, the agreement is made, but the freedom is not absolute, but relative. It is laws, it is always related to the public interest. Agreements made in accordance with Article 1320 of the Civil Law, Civil Code have binding force. Freedom of contract is of the most important principles in the law of agreements. Freedom is manifestations of free will and emanation of human rights. The principle of consensualism is contained in Article 1320 of the Civil Code, which implies the willingness of the parties to bind themselves to each other and to participate in each other. The principle of consensualism determines the existence of an agreement. The willingness of the parties generates trust that the agreement is fulfilled. This principle of trust is an ethical value that has its source in morals. The basis of consensus is found in pacta sunt servanda, or the promising is binding, and promissorum implendorum, obligation, or we must fulfill our promise. The principle requires both parties to fulfill and carry out the agreement. This principle of balance is a constitution of the principle of equality. The creditor has the power to demand performance if necessary can demand repayment of the achievement through the debtor's wealth. But the creditor also bears the burden of carrying out the agreement in good faith. It can be seen that the strong position of the creditor is balanced by his obligation to pay attention to good faith, so that the position of the creditor and the debtor is balanced. The application of the principle of balance is that both parties fulfill and carry out an agreement that emphasizes the balance of obligations between the two parties and is not burdened by one of the parties. Both parties equally get the sum that get the same opportunity balance while carry out these business activities. The application of the principle of consensuality is the achievement of agreement in matters that have been agreed upon. The implementation of the principle of good faith for the existence of a reciprocal relationships and reciprocal process between the franchisor and the franchisee for a long time as long as the agreement is still running and in receive the rights agreed upon by both parties. The implementations of the principle of confidentiality is to jointly confidentialize data provisions that are considered confidentially by both parties, which are justified for notification to third parties. In franchise, the principle relates to the characteristic contained in a good or service offered. The implementations of the principle of legal equality is that there is no distinctions of degree based of any parties between the franchise and the franchisor. Both parties are required to respect each other. The implementations of the principle of freedom of contract is that franchise agreements include agreements that are not known in law but are regulated in Article 1338 of the Civil Code. In the practice of implementing franchising, franchises and franchisors must both get legal protections related to the trademarks related to intellectual property rights or IPR number 15 year 21 on trademark is one of the legal basis for the establishment of trademark franchise. Protection of the implementations of the franchise is closely related to the notions of trade secrets. The trade secret in question is contained in Article 1, Paragraph 1, number 30 of 20 of thousands. I, I repeat, in Article 1, Paragraph 1, number 3 of 20,000. Number 30 of 1000. Concerning trade secret is information that is known by the public in the field of technology and or business as economic value because it is useful in business activities and is kept confidential by the owner and trade secrets. The elements contained in trade secrets are as follows. Number one, the existence of confidential business and technological information. Number two, there is an element of economic value. Number three, an attempt to maintain product security and confidentiality. The element of business information and technology that the business keeps confidential includes customer lists, food and beverage receipts, and other processes that produce goods and services. The economic value element contains information that has economic value in business activities. Information intended to prevent third parties from engineering the same product. The element of maintaining product security and confidentiality must be maintained by both parties in a reasonable, proper, and appropriate manner. Based on Article 4 of Law number 30 of 2000 on trade secrets, the owner of the trade business has the authority to use the trade secrets disclosed and to grant licenses to or other parties to use his secret trades to use his trade secrets or to disclose the trade secrets to third parties for commercial purposes. The implementations of the practice of keeping trade secrets in this franchise business has undeniably found many irregularities. When deviations occur, dispute resolution does not necessarily have to grow through litigation or court because it can be resolved through arbitration by mediation, negotiation, and conciliations. Pursuant to Article 5 of Government Regulation Number 42 of 2007, the franchisor or seller in writing shall include the following: 1. Clear names and addresses of the parties. 2. Type of property and intellectual rights. 3. Business activity. 4. Rights and obligations of the parties. 5. Operational training and marketing assistance, facilities, and guidance provided by the franchisor. 6. The business area. 7. The term of the agreement. 8. Procedure of payment of fees. 9. Ownership change of ownership and rights of heirs. 10. Dispute resolution. 11. Procedures for extension, termination, and terminations of the agreement. The parties to a franchise are the franchisor, franchisee, continuing franchisor, and continuing franchisee. Franchisor based on Article 1.3 of MOT 71 of 2019, an individual or business entity that grants the right to utilize and or use its franchise to franchises. Franchise is based on Article 1.4 of MOT 71 of 2019. An individual or business entity granted the right by the franchisor to utilize and or use the franchise owned by the franchisor. Continuing franchisor based on Article 1.5 of MOT 71 of 2019, a franchisee who is granted by the right by the franchisor to appoint a continuing franchisee. Advanced franchisee based on Article 1.6 of MOT 71 of 2019, an individual or business entity that receives the right from the advanced franchisor to utilize and or use the franchise. The parties involved in the implementation of franchising based on Article 4 of MUT 71 of 2019. According to Article 7, Paragraph 2 of MOT 71 of 2019, in accordance with Article 10 of MOT 71 of 2019, the parties to a franchise must have an STPW. Article 1.10 of MOT 71 of 2019, STPW is a proof of registration of a franchise offering prospectus for advanced franchisors and proof of registration of a franchise agreement for franchises and advanced franchises granted after fulfilling the registration requirements. STPW is submitted through the OSS or online single system institution under the supervision of the Directorate of Business Development and Distribution of Stores concerning of 1. STPW franchisor originating from overseas. B. STPW of domestic franchisor. C. STPW franchisee of an overseas franchisee. D. STPW of a continuing franchisor and an overseas franchisor. E. STPW franchisor of advanced franchises and domestic franchises. The agency in charge of trade or the one-stop integrated unit in the Jakarta Regency or city area throughout Indonesia will process STPW applications through OSS, including A. STPW for domestic franchises, B. STPW for franchises of continuations of overseas franchise, C. STPW for franchise of continuations of domestic franchise. In OSS, when the search section is written franchise, several things will appear, including 1. NIB, business identification number, 2. Plan for the use of foreign workers or RPTKA, 3. Environmental license or SPPPL, 4. Fulfillment of IMB standards, composite standard or per part or SNI. 5. Fulfillment of SLF. 6. Trading business license or SIUP. 7. STPW. A. Other commercial licenses according to business activities and products. Based on Article 2, Paragraph 2 of MOT 771 of 2019 on franchising, the criteria for franchising are as follows. A. Has special characteristic. B. Proven to have provided profit. C. Have standards for the service of good and or services offered made in writing. D. Easy to teach and apply. E. There is continuous support. F. IPR that has been registered. Before the franchisor and franchisee sign a franchise agreement, the franchisor must submit an offer prospectus to the franchisee. The prospectus must be in Indonesian, while the prospectus written in foreign language must be translated to Indonesian. The prospectus in Indonesia contains written information about the franchise business in accordance with Article 7, Paragraph 2 of the Indonesian Government Regulation number 42 of 2007 concerning franchising, regulating identity data of the franchisor, B. Business legality of the franchisor, C. History of its business activities, D. Organizational structure of the franchisor, E. Financial statements for the last 2 years, F. Number of business premises, G. List of franchises, H. Rights and obligation of franchises and franchisees. The franchise offer prospectus is based on Article 1.7 of MOT 71 of 2019 in the form of written information from the franchisor, which is at least explains the identity, legality, history of activities, organizational structure, financial system, number of business premises, list of franchises, rights and obligations of franchises, intellectual property of the franchisor. The prospectus of the franchise offers the to prospective franchisee or prospective further franchises no later than 2 weeks before the signing of the franchise agreement. Matters contained in the franchise agreement include the following. 1. The right to use the trademark, trade name, and good name of the franchisor. 2. The right to use the franchisor design, patents, work methods, equipment, and product development. 3. The right to use all central service development activities to access the franchise. 4. Exclusive right to operate in a particular location or area without competition and other franchises. The existence of franchise agreement that is implemented for a long time is based on the principle of freedom of contract in accordance with provisions of the valid terms of the agreement. In the case of food and beverage franchises, they have the following criteria as stated in Government Regulations number 42 of 2007 concerning franchises. Namely, one has business characteristic, two proven to provide benefits, three have service standards for goods and services met in writing, four can be applied, five there is continuous support, six IPR that has been registered. The British Franchise Association, or BFA, defines a franchise as a license agreement granted by the franchisor to the franchise which contains A. Give the franchisor the right to carry out supervision that continues during the period. B. Requires the franchisor to provide assistance to the franchise in carrying out its business in accordance with the subject of the franchise related to the provisions of training and merchandising and others. C. Requiring the franchisee to periodically during the franchise period must pay a sum of money as payment for the products or services provided by the franchisor to the franchisee. D. Not a transaction between a holding company and its branch or between branches of the same holding company or between individuals and the companies they controls. The franchisor's responsibility for the actions taken by the franchisee are A. Interim justification. In this case, if there is an influence on considerable interference from the franchisor on the course of the franchise business which is actually managed by the franchise. B. External justification. Namely, if there is an expression to the public in such a way that it seems if the action is carried out by or on behalf of the franchisor, the franchise agreement is made by the parties, namely the franchisor and the franchise, both of which are legal subjects, either as a legal entity or only as an individual. Some of the ways the franchise can be used in providing legal protection are as follows. One, assessing sustainability to become a franchise. The increasing competition is in the franchise business, and almost most of the national entrepreneurs or local franchise are not ready to face competitions in the era of free trade. So some efforts are taken to protect and advance local franchises in order to compete with foreign franchisers. Thus, the existence of local franchise business is not left behind from its development. Efforts should be made to protect and advance the franchise, especially from the role of government, among others, namely A. Encourage national companies, or BUMN or BUMD, private and cooperative, that meet the requirements of the franchiseability index as a local franchisor. B. Establish a body that serves as a franchise development center with the task of organizing mandatory activities attended by members such as training, consultation, and counseling if there are problems faced by its number is running in its franchise business. C. Protect and encourage local business that have the potential and are oriented towards export to introduce their products. C. Protect and encourage local business have the potential and oriented towards export to introduce their products. D. The government needs to form coordinating body to develop national productions. D. Number two, weighting the advantage and disadvantage of franchising. According to Amir Karanov, in business success through franchising, there are three reasons for franchisor to franchise their business, including the following. One, lack of capital for business expansion or wider market. Two, lack of personnel to run the business. Three, to expand or and penetrate the market quickly. Franchise-related agreements are not only related to license agreements, but there are many other agreements related to franchising, including one, debt and credit agreement, arises because not a few prospective franchise require loans from other parties to make fee payments as working capital. B. List of business premises arise because it is the main key in marketing. Strategic location is a factor for leasing activities to the franchise. C. Business premises contractions agreement arise because sometimes there are some franchisors who emphasize the existence of a distinctive building that describes the business. From that, it is necessary to have a business premises contraction agreement if the place used by the franchise is not only a privately owned land or place. The equipment leasing arise because in the implementation of some franchises require the rental of supporting equipment during the business. Franchise will not involve either directly or indirectly the franchisor if the franchise is involved in legal and or non-legal claims made by other parties related to negligence of the business being managed. Intellectual property rights, or IPR, are generally grouped into two groups, namely industrial property rights and copyrights. Industrial property right consists of patent rights, trademark rights, in production design rights. Patent right based on law number 13 of 2016 are inclusive rights granted by the state to investor for the results of their investment in technology for a certain period of time to carry out the invention itself or give approval to other parties to carry out. Trademark rights under law number 20 of 2016 are marks that can be displayed graphically in the forms of images, logos, names, words, letters, color arrangements in the form of two dimensions or three dimensions, sound holograms, or a combination of two or more these elements to distinguish goods and or services produced by persons or legal entities in the trading activities of goods and or services. Trademark based on law number 20 of 2016 is a trademark used on goods traded by a person or several persons jointly or legal entities to distinguish with other similar goods. Separate marks under law number 20 of 2016 are marks used on services traded by a person or several person jointly or legal entities to distinguish with other types of services. Trademark rights under law number 20 of 2016, exclusive rights granted by the state to the owner of a registered trademark for a certain period of time by using trademark itself for giving permission to other parties to use it. Based on law number 28 of 2014 on copyright, copyright is the exclusive right of the creator that arises automatically based on the declarative principle after a work is realized in a real form without reducing the restrictions in accordance with the provisions of the legislation. In the legal tangle listed on the franchise agreement, there must be a balancing role of the parties so that there is no division of interest. Because based on the reality that exists in Indonesia, it is not uncommon for there to be termination of the agreement due to default or negligence on the part of the franchisor, default or negligence on the part of the franchisee. In general, the cause of the franchisor terminating the agreement is because the franchisee does not hit the agreement that has been made. Some of the violations, some of the violations of the franchise agreement from the franchise and from the franchisor are delays in disposing franchise fee. Franchise franchisee does not think outside the SOP provided by the franchisor, carries out service requirements that are not in accordance with the agreement, does not return all intellectual property rights to the franchisor after the agreement is over. In this franchise mechanism, there are basically two parties involved, namely the franchisor and the franchisee. The franchisor is usually a large company engaged in the trade of goods or services that are well known both in the world and Indonesian or local. Meanwhile, franchises can be large, medium, or small companies as long as they meet the requirements set by the franchisor and agree to enter into a written agreement. From the description above, it can be reviewed the legal aspects contained in the franchise as follows. One, legal subjects of franchise or franchisee. The legal subject in the franchise consists of two parties, are the franchisor and franchisor, or franchisor and the franchisee or franchisee. In a franchise agreement, the principle of balance is known, namely the principle that requires both parties to fulfill and carry out the agreement properly, namely in the form of fulfilling rights and obligations. The principle is quite important in order to achieve balance in business. Number two, franchise law objects. The name and type of intellectual property rights, inventions, or business characteristics such as management systems, sales methods, or distribution arrangements that are special characteristics become the object of the franchise agreement. Number three, rights and obligations of party in a franchise. In general, the rights and obligations of the franchise can be formulated as follows. A. Obligations of the franchisor. Provide all kinds of information related to the franchise invention or business characteristics. For example, the arrangements of distribution methods which are special characteristics that become the object of the franchise in the context of implementing the franchise. Provide assistance to franchisees in coaching relationships in the context of implementing the franchise. B. Rights of the franchisor. Supervise the implementations of the franchise, obtaining periodic reports on the course of franchise business activities, carry out inspections in the franchise work area to ensure that the franchise granted has been implemented properly. The franchise granted has been implemented as it should. Require the franchise to maintain confidentiality for business characteristics such as management system, ways of selling or structuring or distribution methods which are special characteristics that are the object of the franchise. To some extent obliges the franchise in certain manners to purchase a capital goods or certain other goods from the franchisor. obligates oblige the franchise not to carry out activities that are the same, similar, or which can directly cause competition with business activities that use inventions or characteristics such as management system, ways of selling or structuring or distribution, which are legal characteristics that are object of the franchise. Receive royalty payments in the form of types and amounts deemed appropriate by it, registering the franchise granted to the franchisor. For the view of the franchise, ask the franchise to return all data, information, and obtained by the franchise during the franchise implementation period. Upon termination of the franchise, prohibit the franchise to further utilize all data, information obtained by the franchise during the franchise implementation period. Upon termination, prohibits the franchise to continue to carry out activities that are the same, similar, or directly or indirectly can cause competition by using inventions or business characteristics such as management systems, sales methods, or structuring or distribution, which are legal characteristics that are the object of the franchise. The granting of a franchise, unless it is exclusive, does not extinguish the franchisor's rights to continue to utilize, use, or carry out its own inventions or business characteristics, such as management system, sales methods, or arrangements or distribution, which are legal characteristics that are the object of the franchise. Now, C, obligations of the franchise. One, carry out all instructions given by the franchisor to him in order to carry out the invention or business characteristics. For example, the management system of sales method or arrangement or distribution, which is the legal characteristic that is the object of the franchise. Two, provide flexibility for the franchise who conducts periodic or sudden supervision or inspections to ensure that all that the license has implemented the granted franchise properly. Provide reports both periodically and upon special requests from the franchisor. Three, purchase certain capital goods or certain other items in the context of implementing the franchise from the franchisor. Four, maintain confidentiality, for example, management system, sales methods, or arrangements or distribution methods, which are special characteristics that are the object of the franchise, both during and after the end of the franchise granting period. Six, report any infringement of management system, sales method or arrangement or distribution method, which is special characteristics of the franchise object found in practice. Seven, not make use such as management systems, sales methods, or arrangements or distribution methods that constitute the special characteristics that are the object of the franchise other than for the purpose of existing the granted license. Carry out franchise registrations, not to carry out activities that are the same or similar, or which directly or indirectly may lead to competition with business activities that utilize, for example, management system, sales methods, or arrangement or distribution methods, which are the specific characteristic of the franchise objects. Make royalty payments in the form of types and amounts that have been mutually agreed upon. Upon termination of the franchise, return all data, information obtained. Upon termination of the franchise, does not further utilize all data, information obtained by the franchise during the franchise implementation period. Upon termination of the franchise, no longer carry out activities that are the same, similar, or which directly or indirectly can cause competition by using, for example, management sales methods or structuring or distribution methods, which are special characteristics that are the objects of the franchise. The right of franchise. One, obtaining all kinds information of related to intellectual property rights as sales management or structuring or sales distribution methods which are special characteristics that are the object of the franchise. Two, obtaining assistance from the franchisee on all kinds of way of utilization and use of intellectual property rights, such as management system of sales or arrangement or distribution method, which is a special characteristic that is the object of the franchise. Four, franchise marketing area. The destination of the franchise business marketing area in the franchise agreement can cover all part of Indonesia. This means that the franchise can be exclusive throughout Indonesia, as well as non-exclusive territories which are only limited by certain areas in certain countries within the Republic of Indonesia. Five, franchise period. The term of the franchise agreement is determined to be valid for at least 5 years. Provisions regarding the terms of this franchise agreement can be determined in Article 8 of the Decree of the Ministers of Industry, Trade number 259 of 1997, which reads, the term of the franchise agreement shall be at least 5 years. The term of the agreement can usually be extended again. The franchise should be careful if the franchise agreement it is found that there is no opportunity to extend the agreement. Six, how to settle franchise disputes. In general, dispute resolution can be done through two ways, are litigation and non-litigation. Litigation is a way of settlement through a public court forum, while non-litigation is an out-of-court settlement referred to as alternative dispute resolution, or IDR. Seven, indemnification in the event of termination of the franchise. In the business world, agreement is agreements, including franchise agreements, are very important as guidelines and evidence for the parties themselves. With a good agreement, it will prevent disputes because everything has been clearly regulated beforehand. And even if a dispute occurs, it will help the settlement efforts. In other words, a good agreement will provide great certainty to the parties so as to help the implementation of business transactions. The law provides sanctions against the perpetrators, parties to the agreement, both franchisors and franchisees who violate the agreement or default. Default means not carry out the contents of the agreement, even though the parties have previously agreed to carry out the agreement that has been made. To prevent default and provide justice and legal certainty to the parties, the law provides sanctions is the form of compensation, cancellation of the agreement, and transfer of risk. Such sanctions are civil sanctions because the problem of the agreement concerns personal interests, which are different from criminal sanctions in the form of physical punishment against perpetrators of certain crimes or criminal offense as regulated in criminal law. According to Setiawan, the Civil Code recognizes three forms of default. One, does not fulfill the performance at all. Two, late in fulfilling the performance. Three, fulfilling the achievement in unfavorable manner. Meanwhile, Subjekti divides the poll into four forms. One, not doing what he promised to do. Two, perform what is promised but not as promised. Three, do what was promised but late. And four, do something that according to the agreement should not be done. The compensation can be sued against the fault is the reimbursement of material loss that are real as a result of the default agreement. The compensation can be in the form of costs that have been incurred, loss suffered, and profits that could have been obtained if there was no default. In addition, there is also compensation for immaterial loss in the form of lost opportunities, enjoyment, and the like, of all which need to be calculated in large amounts in the form of money. 8. Procedures for payment and franchise fees. According to the government regulation number 16 of 1997, only regulates the payment of compensation in the form of direct monetary compensation. This means then the type of payment that can be made can be realized in the form of one, lump sum payment, which can be made at once or in several installments. Two, royalty, in which the amount of payment is linked into a certain achievement calculated from the amount of production or or sales of goods and or services produced based on the granting of the franchise whose payment is made periodically, usually on a quarterly, semi-annual or annual basis. Compensation provided not in the form of monetary value or indirect and non-monetary compensation include, among others, one, profit as a result of the sale of capital goods or raw materials, semi-finished materials, including finished goods, which are a package provided by the franchisor, which is often made in the form of an exclusive purchase agreement. Two, payment in the form of dividends or with interest of loans in the event that the franchise license also provide financial assistance either in the form of equity or equity participation or in the form of short or long-term loans. Three, cost shifting or the transfer of some of the cost incurred by the transferring franchisor is usually carried out in the form of an obligation for the franchise to incur all costs necessary to prevent infringement or to maintain protection. The possibility that the franchisor will obtain feedback or development modification or improvements made by the franchisor in various aspects of the intellectual property rights that are licensed. The acquisition of marked data from business activities carried out by the franchise means that the franchisor has wider access to further develop the intellectual property rights license. The possibility of cost savings by the franchise in many ways that this can occur because in principle the operational activities of the license implementation are in the franchise product. This means that the franchisor only needs to supervise the operations of the franchise. Use of those domestically produced goods or materials produced and supplied by small entrepreneurs. This provision is the implementation of provisions of Article 4, Paragraph 1 of Government Regulation number 16 of 1997, which is repeated in the formulation of Article 17 of the Decree of the Minister of Industry and Trade, which states that The franchisor shall prioritize small and medium-sized entrepreneurs as franchises, continuing franchises, and or suppliers of figures for the supply and procurement of goods and services. In the event that the franchisee or continuing franchisee is not a small and medium entrepreneur, the franchisor and continuing franchisee shall prioritize cooperation and supply of goods and or services from small and medium entrepreneurs. 9. Coaching, guidance, and training to franchises. Franchises will be given training on business methods according to the blueprints that have been made by the franchisor. This training usually involves training in the use of special equipment, marketing methods for product operations, and process implementation. Franchises will continuously provide various types or services that vary according to the type of business format that is franchised. In general, the process of assistance and guidance provided on an ongoing basis includes, among others, 1. Periodic visits from and access to the franchise's fields, support, and staff to help correct or prevent deviations from the implementations of the blueprint that may cause trade difficulties for the franchise. 2. Linking the franchisor and all franchises together to exchange ideas and experiences. 3. Product or concept innovations, including research into market possibilities and customization with existing businesses. 4. Training and retaining facilities for franchises and their staff. 6. Market research. And 7. Promotion at local and national. 10. Registration and authority to issue STPUW. This decree of the Minister of Industry and Trade obliges every franchisor or subsequent franchisee to register the franchise license agreement along with the written statement as referred to in Article 5 of this decree at the Ministry of Industry and Trade. Checking the official authorized to issue STPUW to obtain STPW is a franchise registration certificate. Hereinafter abbreviated as STPUW, which is proof of registration obtained by the franchisee after the franchisee has applied for STPUW and fulfill the requirements specific in this decree, Article 1.a. The aforementioned registration carried out in the context and for the benefit and development of the business by way of franchise is carried out by filling in the TPUW request form in duplicate 2 signed by the franchise or continue franchise or its proxy. The registration must be carried out not later than 30 working days starting from the effective date of the franchise. The STPUW request form list has been filled in and signed by the franchisee or continued franchisee or its proxy is submitted to the official authorized to issue STPUW with a photocopy of its accompanying existing franchise agreement along with written statement, trade license or business license from other technical departments. And what the conclusion from the description presented in the discussion chapter, conclusions can be drawn about the normative legal review of franchise in Indonesia based on PP or regulation, government regulation number 16 of 1997, namely 1. Legal aspect franchise or franchisee, franchise legal object, rights and obligations of the parties in the franchise, 4. Franchise marketing area, 5. Franchise period, 6. How to settle franchise disputes, 6. Compensation in the event of termination of the franchise, 8. Franchise royalty payment procedures, 9. Coaching, guidance, and training to franchises, and 10. Legislation and issuance authority of STP UW. We hope this video can be support your business and have benefits for your business and add it to your knowledge about the business in Indonesia, especially in case of franchise business regulations in Indonesia. Thank you.